Not too pleasing, not too pleasant.
You're supposed to be. Here's
Yes.
the problem. Your lawyer wants me to give you a PR bond, but you picked up a theft case. You're supposed to come to court. You didn't come to court. You took off on us. We issued you a warrant. We issued a warrant. The only reason we have you now is because you picked up another theft case. So why? Why would we continue to do the same thing?
I attempted to come to court, but you see, there's no
So
buses coming out of Kingwood.
Notice the excuse here. No buses taking care of grandma. But the judge isn't buying it. Why? Because in law, responsibility doesn't vanish just because life gets hard. What do you think? Should personal struggles be a valid reason to skip court dates?
And I was taking care of my grandmother in Kingwood. So I tried, I tried, we tried to get Uber money and everything, but I couldn't make it, and I called.
Wait a second. He claims a Purple Heart veteran discount applies to theft? That's not how the law works. Military service is honorable, but it doesn't exempt you from paying for Walmart groceries. Wild defense strategy.
Called in, and
we don't have any record. The only reason we have you now is you picked up a new theft case. What happened on the theft case, Alex?
So on the most recent case on March 2025, the officer was dispatched to a shoplifting call at a Walmart. The officer made contact with Officer Chin, who stated that he recognized the defendant from a previous encounter and observed the defendant grab multiple items in an attempt to leave the store, passing at all points of sale without committing theft. The defendant stated he has owed Purple Heart veterans discount. Therefore, the amount stolen should be less than listed due to the father's military service. The defendant said he was trying to find his ID that he dropped outside the Walmart, and that is why he passed all points of sale and attempted to leave the entity. And the defendant further stated that the warrant should be invalidated due to him not stealing on the prior theft as well. Total was $283.62.
this is all not how. Okay.
Was he ordered in the first theft case not to go back to the? So they're both at Walmart, right?
No.
Melrose.
Yes, sir.
It's Melrose.
Retail clothing store, so my understanding is
Are you sure?
we don't check ID. It's just a clothing store.
Do you see any other criminal history?
I see only previous interference that was dismissed, but nothing else besides that.
What do you think, Mr. D?
I think that I think he would conform to the requirements, Judge. He stated
Did before.
I understand. He made a mistake there. We all make mistakes in life. He said that it was attending to his ill mother. That's not a reason for him now.
I just turned 30.
What do you do with yourself these days?
I'm a farmer. In the Virgin Islands, I have a farm. I'm a COO, True Farm Hydroponic Goods. We have a farm in Florida, Palmetto, Florida, and we have a farm in St. Croix, U.S. Virgin Islands. I'm trying to expand to make a ranch over here in Houston.
Who do you live with then?
My grandmother, she's battling breast cancer.
Here's the thing. If I give you another PR bond, and that's a big if, I don't want you out on the street because I don't know what you're doing with yourself. I don't know who you have in your life now. So the first thing that I would like to know is that if we give you a PR bond, where are you going to go? If it's out on the street, I'm not going to do this again. But what I'd like is to see, if you don't mind, reaching out to maybe any family members to see
That's a famous courtroom line. Fool me once, shame on you. Fool me twice, shame on me. Judges use this to make crystal clear that second chances don't come easy. Quick poll. If you were the judge, would you risk giving him another shot?
who he has there to go home. If you have, you said grandma, if you have a place to stay, then great. We can verify that so that we know that you're going to go. And the next thing is, if I give you a PR bond, I'm going to put a monitor on your ankle so I know where you are. because you're a flight risk. You've already proven to us that you're a flight risk. And so I'm concerned if I give you a PR bond, you're going to take off on me again. And I don't want that to happen because I'm not going to play this game with you. You know, fool me once, shame on you. Fool me twice, shame on me.
So,
You already fooled us once. I'm not going to do this again.
yes, sir.
So what I'd like to know is if you have a stable place to stay, and then we'll go from there. So do you mind reaching out to see if he has a place to go to? If grandma will take him in, then I will give you one more chance, but it's going to be with a leg monitor, so I know where you are. And if I find that you ever go back to a Walmart again, away go all your PR bonds. You know, you now have no one that's going to bond you out. So the next time someone alleges that you commit something and you end up going to jail, you will be stuck like Chuck in there because no one is going to post your bond. This is what you need to think about when you're out there in the free world. Do you understand?
Yes, sir.
If I do this, what's going to happen? If I say this, what's going to happen? That's what you need to think about. So let's see what we can do about finding you a place, and then if so, we'll go further. All right? Okay.
You see something on Mr. McIntosh, the one we just spoken about the place to stay. I spoke with his grandmother, Mrs. Gladys Sanchez. Mrs. Sanchez informed me that she would be willing to let him stay there for a period of 2 months if he tries to get a job and stays out of trouble. She's willing to do that. She says she can't let him
That sounds
stay.
fantastic.
She says she can't let him stay there indefinitely. She can't let him stay there indefinitely because he is not.
This is a classic example of the court balancing compassion with accountability. Notice how the judge gives him structure, temporary housing, job hunting, sobriety. What do you think? Is 2 months enough time to turn someone's life around, or is it setting him up for failure?
Not on the lease, but she is willing to make a sacrifice
So
of
what
2 months.
we'll do is we'll bring him out. Then we'll give him 2 weeks to see what he's done to get a job. We'll go there. That's also a condition of his bond as well. You know, we'll put a monitor prior to release so we know where he is.
Yes.
No dope, no alcohol.
Yes, sir.
So he knows not using.
Yes, sir.
That's it after that, right? That's it. So, but if you're going, Deputy Miranda, when someone works in jail, do they get paid? Isn't it true they get like maybe 5 cents per hour or something like that?
Some of the ladies have more, one thing, that the workers will get more time on base. So don't expect that sometimes they do going to work, workers don't, 21.
But they don't get like any kind of real money, no real money. It's only you're working full time. What I was going to say is you can either get a job in the real world and make real money, or you can work in the jail. Because if you want me to let you out, there's a couple things you need to do. Number one is get a job. Your grandmother is willing to let you stay there, but not indefinitely. You're not on the lease. So you have a limited amount of time that you can stay there. The other thing you need to do as part of her condition for you to live with her is you got to get a job. Do you understand?
Yes, sir.
People who don't have anything can't be picky. So don't be picky where you want to work. Any job is a good job as long as you're making at least minimum wage and it's verifiable employment so that we know it's real. Okay? I'm going to give you another PR bond now, but I'm not going to do this again. If you pick up a third case, I'm going to go absolutely bonkers. You know no one's going to bond you out. So think before you act. You are not allowed to go to any Walmarts. And I'm going to bring you back in 2 weeks.
This
See
moment
what-
is key. The judge basically says, don't bite the hand that feeds you. Your grandma is your lifeline, your housing, your chance at freedom. If you mess that up, you're not just losing a roof. You're losing your last bridge back to normal life.
See what you have done to get a job. You must put in at least 10 to 15 applications. It doesn't matter where. Lowe's, Home Depot, McDonald's. Don't be picky. You have to get a job. The other thing is no dope, no alcohol.
Yes, sir.
I'm going to test you. I'm telling you now, I'm going to test you on your release so I know that you're not using.
Yes, sir.
You understand?
Yes, Your Honor.
Any questions?
Job.
Job. Drug and alcohol free, and be nice to your grandmother. Because if she's nice enough to give you a roof over your head, don't bite the hand that feeds you, because then your butt's going to be on the street. Do you understand?
Yes, sir.
Anything else, Mr. D?
No, sir, that'll be all, Judge.
Okay. You will get a GPS prior to your release so we know where you are, and I want you back here in 2 weeks to show me what you've done to get a job. If you have done nothing, it's not going to go well. You understand?
Yes, sir.
Okay. All right. So, good luck, Ms. McIntosh.
Thank you, Your Honor.
Judge, keep the bond as I for PR bonds.
Okay.
On March 2nd, 2025, officers were dispatched to an accident call at 40.
Whoa, this escalates quickly. Passed out, slurred speech, and even admitting to hitting something, but here's the kicker, no one actually saw her driving. That's a huge legal gap. Should an admission alone be enough to prove guilt, or do we need solid eyewitnesses?
500 block of Southwest Freeway. The defendant was passed out in the passenger seat of the tow truck. The officer noticed that her eyes were low, that her speech was slurred, and that her breath smelled like alcohol. The defendant urinated on herself. The defendant stated that she had one drink and that she was coming from a. The defendant showed to be have lethargic behavior. The defendant confirmed that she was the driver and that nobody else was with her. After the test was conducted, it was a 6 out of 6 on the HGN, 6 out of 8 on the walk and turn, and a 1 out of 3 on the. Sorry, 3 out of 4. No one likes that.
The driving. All we have is her admission that she's driving.
Yes and no, Your Honor. We do not have anybody that put her driving. Anybody that sees her in the driver's seat. I spoke with the officer on Friday after we left court. He stated that once he was dispatched, the defendant was no longer in the driver's seat of the vehicle. The vehicle is on the scene, clearly having front end damage. The officer speaks to the tow truck driver who was there and stated that and learned that that tow truck driver did not see her driving, but another tow truck driver was there on the scene earlier, and that when there's a lot of tow truck drivers. When the tow truck driver arrived, the other tow truck driver and the defendant were standing outside of the vehicles. So we never
Even saw her in the car.
No, Your Honor. However, this is on a major freeway. I can pull up Google Maps if that's good for you.
No, I believe it. I get it.
3 lanes to the left of traffic. There are 3 lanes to the right of traffic. There is no way
Or otherwise.
for her to leave without honestly being run over. And that's the case law that I've shown you, that she admits to driving, and that
Problem I also
along
have
with the conjunction of that there's no other way for her to get there or to leave. That is just
was there any
Sure.
alcohol in there? Any?
in the vehicle. No, we don't have any.
Did you provide any case law that says that an admission is sufficient?
The admission along with corroborating evidence that shows that there's no other person who could have been driving.
There's one thing, she also denies driving.
Yes, no. So on Friday, when I spoke with the officer told me that she did not outright admit to driving, and that is correct. And through my notes that I emailed him, I put 6 minutes deny driving. It's not exactly correct. What the officer did say is ask, where are you coming from and where are you going? And she answered those questions. So based on that information, we can say that she was admitted to driving.
I can't say that. That's assuming. You can say, oh, I went there, I went here. I didn't drive this morning. I took the bus this morning.
She also admitted that she was in an accident. She stated that she hit a Because they're at the same time they're investigating FSGI.
That's new information. I mean,
It's in the body cam, Your Honor.
so I wasn't privy to that last week. Again, so now we're on statement only. So, oh wait. So I'm
Sorry.
with you.
No, just that she said that she was in an accident because they're investigating FSGI, and the defendant stated that she hit some sort of. The officer is asking, "Did you hit another vehicle?" And she says, "No, I hit some sort of vehicle."
Okay.
I know with SGI, they're unable to charge that case because they can't identify who the driver.
So the complaint, there's a separate white car that's been in an accident off of the freeway. They're trying to connect this defendant to the FSGI. That driver of that other vehicle, the complainant, isn't able to say who it is. So we did not have these charges.
Do you have a case that says that an admission?
Yeah, that's in case 3. Something like email, something 1957. You know, say, I think Dansby.
Case from like, it's a case from 1852.
No, my case. No, 7. So I was like, everybody knows this. Thomas Delecti. That's in the state's case. The state cites to Fisher, which is the same proposition that,
To the conclusory case?
I'm not sure. I think it's 4. No.
Oh, go for it.
Yeah, in Fisher, we talk about the corpus delicti rule, which is the defendant's admission.
Traditionally, I agree with you, right? Like, the statement in and of itself is insufficient.
Right. So
We have other evidence there, like what she's saying, corroborating evidence, you know.
no, I would dispute that. You're saying that her being on the highway alone would be the other way around. If she was in a parking lot alone, the case they presented to you, it's a lighted parking lot. It's more likely that
She's in the middle of a freeway.
right. So it's more likely you're not going to find someone that's left seen, as opposed to if you're in a parking lot with lights and street lights. You're probably going to find that person walking down the street.
Your Honor, we'd argue that if they're in a freeway, there is nowhere for another person to go. The person would not.
How could there possibly be someone else? I mean, if you're,
There's all kinds of places you can sneak into. There's sewer, jail.
This is why.
People walk into the store. Yeah, I'm just telling you. I don't know why we're assuming everything they say is like grace. In the case they presented to you, there was a restaurant where the defendant was found. Today they've said that my client admitted to owning the vehicle. I'm not aware of that. That wasn't presented to me last week.
In the dip zone, Your Honor. And the officer did run the car. It did come back registered to the defendant.
So again, that would be from her statement, unless there's some hearsay there. They're now saying that corroborates that. In the case they presented, there's a bar nearby where person is the defendant claims they were not drinking. The way it was presented last week is, I went here, I went here, I went here. It wasn't, I drove there. There was no admission. You still wouldn't have a witness to say that she was operating. Did you get my email? Because I want to make sure.
I'm waiting for you now.
That's the original one. Yeah.
What's the
whole
is it still good?
Yeah. There's nothing.
Have you seen 3?
Sorry, Your Honor?
Did you send it to them?
I have seen them all.
And it's an oldie but goodie. That's exactly the same situation. And then
No, it's like right on point. It's like here we have, except for the fact that, like in 3, he's at a hospital, makes an admission. Where here, still on the scene.
You see that rule? The
it's in a record car.
Okay, I'm meaning, but she's still
right.
close to the car.
And that would be our argument, is that distinguishing 3 from the case that I mentioned to you is that in 3, the defendant's not on the scene. Somebody else could have driven. as opposed to the case where I showed you, which showed defense counsel and you as well, Your Honor. It is a Whataburger parking lot, I believe they're in. Maybe it's
Right.
McDonald's. It's a fast food restaurant. The defendant is found inside the restaurant, and the car is outside of the restaurant. But the court found that based on the totality of circumstances, looking at the surroundings, that the defendant's admissions combined with the fact that it was his vehicle, that he was right there, that it was enough to prove.
Yeah, that's the distinction that I think, is important because all of that is near itself as far as premises of the defendant. Everything here is not near the scene. It's not all one little package. I don't know where she
Why
went.
not? What do you mean? Why not? The only difference here is that she's sitting in a record truck, but we have.
She went to all these places. I don't know where they are, or if she went, and so in this case, they have evidence.
So the officer, hey, where are you coming from? Where are you going? And she says, hey, I was,
Coming from a club.
dancing.
Right, whatever. You San Antonio? I don't know. I don't know where that's from. Here, they know where the water
Is it relevant? Where? I don't care where. My only concern is she driving.
Right.
Yeah, I should care where she is.
Exactly. And that's where, again, she's not saying she drove there. She's saying that she was there. So
She's saying that she was going home, Your Honor.
someone was driving.
What's the exact statement that she says?
I don't have these. It was on body cam. But I have from the offense report, if I can pull that up.
Why don't we put it off till tomorrow so you can take a look at what she's looking at? That way you can make an informed argument. Are you okay with that?
No, I'm good anytime. I'd like to postpone always.
I asked the suspect where she was coming from. She stated good moods, a club in Houston, Texas. That she was
So there
going
it
home.
is. The hammer drops. The judge warns. One more DWI, and you could face 10 years. Imagine that. Your entire future changed by a single drink and a car ride. Be honest. Should repeat offenders get harsher punishment or more rehab opportunities?